Hello everyone, I am Kriti. Welcome to Inside the Courts by Rahul IAS, your crisp and curated briefing on the latest judicial developments shaping India's legal landscape. Today, we condense complex litigation into actionable insights from the rigorous standards of the BNSS to the finality of international arbitration. Let's get straight to the bench. First up, the trial court's power to summon additional accused under Section 319 of the CRPC, which has now transitioned to Section 358 of the BNSS. In Yadvinder Singh versus Lakhi, the court emphasized that this power is an extraordinary discretion that overrides police findings. The court restored summons against the individuals named by eyewitnesses in a murder case, even though a special investigation team had cleared them earlier. The bench clarified that while the threshold for summoning is higher than a prima facie case, requiring strong and cogent evidences, courts should not conduct a mini trial to weigh defense evidence at this stage. Thereby, the bench reinforced that judicial evidence presented under oath outweighs investigative conclusions, ensuring that potential culprits do not escape justice due to a manipulated or incomplete investigation. Continuing to the theme of judicial pragmatism, we look at the duties of the prosecution through the case of Sandeep Yadav versus Satish. The division bench in this case has reinforced the principles of substantive justice over technical perfection. The court has ruled that an unsigned charge sheet is a curable irregularity and not a fatal flaw. Under the doctrine of procedural law, technical omissions do not vitiate the proceedings unless they cause a failure of justice. Third, on jurisdiction and sanctions, in the case of Samarendranath Kundu versus Sadhana Das, the Supreme Court held that a subsequent requirement of sanction under Section 197 of the CRPC cannot invalidate cognizance already validly taken. Relief granted to a co-accused on a later sanction ground cannot be extended if no such requirement existed at the time of taking cognizance. Next, turning to the civil law, the doctrine of res judicata has been further refined in the case of Sharda Sanghi versus Asha Agarwal, which has clarified that a dismissal of a suit for default does not constitute an adjudication on the merits of the case. Consequently, it does not operate as a statutory bar to a subsequent suit under Section 11 of the Code of Civil Procedure. However, the code issued a stern caution that parties must not misuse this to revive abandoned claims. Moving on, in the domain of the alternate dispute resolution, India continues to cement its status as a pro-enforcement jurisdiction. In Nagraj versus PI Opportunities, the Supreme Court adopted the doctrine of transnational issue estoppel. The mandate is clear. Under Section 48 of the Arbitration and Conciliation Act, enforcement is the rule and refusal is the narrow exception. Once a seat court decides an issue, Indian courts will not reopen it. Furthermore, the principle of dispute finality has been further emphasized in the case of Rajiv Gadh versus Subodh Prakash. The bench has drawn a direct parallel between civil and arbitral proceedings, ruling that the principles of Order 23, Rule 1 of the Civil Procedure regarding the abandonment of claims applies equally to arbitration. The court noted that a party abandoning arbitration cannot reinitiate the proceedings on the same cause of action without prior permission, and a subsequent judgment does not create a fresh cause unless it materially alters the party's rights. On to the legislative front, the Transgender Persons Bill has officially received the President's nod, codifying essential statutory protections. Finally, the biggest headline remains the Sabrimala Reference. In a definitive move for Indian law, a 9-judge constitution bench led by CJI Suryakant has begun re-examining the 2018 Sabrimala ruling to finally draw the line between religious freedom and the right to equality. During yesterday's arguments, Solicitor General Tushar Mehta urged the court to stop deciding what is essential to a faith, contending that Article 25, Subclause 2, was designed to fix caste-based exclusion and not gender restrictions. This was met with key judicial observations, notably from Justice Nagaratna, who clarified that the historical context of untouchability under Article 17 of the Constitution cannot be extended to biological conditions like menstruation. As the bench weighs whether constitutional morality can override a religion's autonomy, the final verdict will set a massive precedent for attacked cases like female genital mutilation and the woman's entry into mosque, with hearings expected to be wrapped up by April 22nd. With this, we conclude today's edition of Inside the Courts. I trust these insights will sharpen your practice and your perspective. I am Kriti. Thank you for watching.